Good morning, Your Honors.
Good morning.
May it please the Court, Tim Richardson on behalf of Randy Denning. I'd like to officially reserve my rebuttal time, please.
Please.
Your Honors, just a brief set of the facts. Randy Denning is an impaired individual with a chronic pain and an intrathecal pain pump. She had an agreement with AIS to provide medicine to this intrathecal pain pump. She signed 2 contracts with AIS, and I think that's what's integral to this case. The fact that she was in a contract, 2 separate contracts. The first one, it was Exhibit 1 to our petition. It authorizes or consents to AIS providing services to me pursuant to the orders of the physician, and I understand the physician listed above prescribed this therapy for me and authorized this physician to send AIS Pain Care a prescription on my behalf for the medication. That's the first of the contracts. The second one says, and I'm putting part of this, I understand that my insurance company may not provide payment for all the goods and services provided by AIS. And it also says, I understand that I will be responsible for payment of any remaining balance during the course of my therapy.
The standard guarantor situation when you get treatment. What is it that you seek? What kind of damages, how is the injury redressable?
Yeah, and that's a great question. That is the central issue in this case. The argument that my friends on the other side have is that Ms. Denning hasn't sustained any injury. That's the argument, the injury in fact. To the contrary, we believe she sustained injury because the injury is she didn't receive the in-home fusion therapy.
Okay, assuming that she didn't receive that,
Right.
we agree, assume arguendo, we agree with you that she suffered an injury in fact. For us to allow the case to continue, the injury still must be redressable.
Right.
Can we have you asked for anything that a court could give you, Ms. Denning, that would redress this injury?
Thank you, Your Honor. Paragraph 24C is what I'm going to refer to in the petition. In 24C it says, where plaintiff's insurer has paid for these services, or plaintiff, the amount of insurance, let me back up, I'll read the whole thing. As a consequence of, this is 24C, as a consequence of AIS's billing plaintiff and or the health insurer for services not rendered, plaintiff's patrimony has been depleted, where plaintiff either personally has paid for those services and where plaintiff's insurer has paid for those services, and this is where we cite it, the amount of insurance available to plaintiff for a particular term has or has been improperly depleted through AIS's actions. And that's,
are you seeking injunctive or declaratory relief if the allegedly fraudulent invoice is retracted so that your client's insurance benefits are not depleted?
we're seeking, moving forward, we believe, by this lawsuit, by having them be accountable for once they bill the insurance to either provide the service, is what we ask, or reimburse the client for
out of pocket.
Well, I believe, this is my thought on this. This is a diversity case. So Louisiana Civil Code Article 1986 states, upon an obligor's failure to perform an obligation to deliver a thing, or not to do an act, or to execute an instrument, the court shall grant specific performance plus damages for delay if the obligee so demands. But if specific performance is impractical, the court may allow damages to the obligee. So my point being, I can't go back in time for the last 2 years that AIS has been billing for this service they're not providing. But what they did do is they took from my client her right to have that service every day. Because remember, there's an S code. S code is home infusion therapy. So my client, under her contract with her insurance company, every day has a right to have someone come to her house, infuse her pump, and monitor her.
And didn't that happen?
Did not happen. Her pump had to be filled through the doctor's office. So what they're claiming they're doing, according to the way we understand it, is that they're charging $120 a day, coding it under this home infusion. They never go to the house. Ms. Denning's never seen them. It just doesn't happen. Their argument, though, is, well, wait, we supply medicine. She got her medicine. That's true. Their argument is, we got paid for the medicine, but every day the medicine drips through that pump and into her body. We get to charge another $120 a day for each day that the medicine goes through the pump.
Did she have out-of-pocket costs
She had
associated with the fact that her insurance benefits were depleted?
She had to pay for her insurance, so she pays for her insurance, and then because of that insurance being paid, right, then her patrimony has been depleted because she's not receiving the service. But maybe I can address this, Your Honor, because I was thinking about this. I'm sorry.
To answer the question, though, did she have out-of-pocket costs for the services? Well, I understand she paid for the policy.
I do not believe...
What's your direct answer to that question?
Yeah, I'll answer that question. I do not believe that they have billed Miss Denning yet for anything out of pocket. I believe it was all billed to the health insurer. I think that is true. Does that answer your question?
So they haven't sent the guarantor a follow-up or something?
No. We found these, she found these, consulting with us through her EOBs. So when she was going through her explanation of benefits, it's all over the place. And when she looked at it, she came to us, what is this? Why do I have hundreds and hundreds of charges for something I never...
Does this policy have lifetime benefits such that this would exhaust it, prematurely be exhausted because of these charges?
I don't think so. I don't know the answer to that, to be honest with you. I do not know. The problem that I have with it is we have somebody who now has on her insurance hundreds and hundreds, right, of charges that are never happening.
But they weren't charged to her.
They weren't, but they're still, I say they weren't, but let me back up on that. You're correct, Your Honor, in that she did not pay directly. However, the argument that the other side makes is it was the health insurer that paid these amounts. That's what the argument is. But here's the fallacy, I think, in that whole argument, kind of the fundamental disagreement I have with them. How did the insurance company get the money? It came from the premiums of my client. It's not like Gills Bar is going into their internal profits and saying, here you go, AIS, here's $120 a day. Ultimately, the people who are paying for this service are the patients. This is why this is a class.
So you
right?
have a breach of contract, clear enough, but no out-of-pocket directly by her. So do I understand you're seeking retrospective relief? You're not seeking prospective relief. Is that right?
So we are seeking both. Retroactive relief for what they did charge and didn't provide the service, and prospective, if they're going to charge, then do the service.
What are you saying the service is?
They go, so these people have these pain pumps, and I'm sure you're familiar, Your Honors, with how that works. They bring the needle in and fill the pain pump with medication. A lot of these chronic pain people, Ms. Denning, for example, it's very difficult for her to leave the house and go sit in a doctor's office. They would come in and infuse them at home.
Who would come in?
AIS. AIS would come to these patients' homes and go in and fill their pumps and then can monitor them and get in-home therapies. That's what the bill is. Their argument, though, and again, which goes to the merits, which is we can bill $120 per day because we supplied the medicine that the doctor put in, and because it's dripping through your body, we get $120 a day for this per diem rate of what goes into your body every day, which we think is absolutely wrong. They're not providing that service, and we believe we have standing to bring the claim. And I'll tell you why also.
So you only have the right to bill the $120 when you go to the house and install it that day, and then it runs out, and then the next time you go. That's what your position is. Is that right?
That is correct, Your Honor.
Okay.
Or alternatively, to go to the home and monitor them to make sure everything's doing correctly. So I would agree, if they fill the pump, $120 a day, no problem. If you go and visit the client at the house and check to make sure everything's being done right, $120 a day, I think that's fine. The problem that we have is that if you take a right of a patient, so let's think about this for a second. If they bill that code, so let's assume I'm Miss Denning and I want my pump filled today. If they bill the code and they take that from me, I can't have somebody else come into my home and fill my pump because they already took the code. That's the problem. If this continues, never, ever, ever will Miss Denning ever be able to have anybody come to her house to fill
She's already exhausted that. It's already shows on the thing she's already gotten that. And so you need to get that off of there so that she can have that still remaining in her policy.
Well, that, and let's assume for tomorrow. So
Yeah, that's what I'm saying. For tomorrow,
Yes.
you need to get it off of there for yesterday so it doesn't count against her.
True.
Are they not willing to take it off if they don't think it's false? I thought they
No,
agreed
I
that it
don't
was
think
in
they
error.
took them off. But moving forward too, I'm saying for tomorrow, let's assume they did take them off. Let's assume they did. Let's just roll with that for a
Yeah,
second.
if they take them off, then she still has that right in the future.
But not if they take it. So tomorrow, if they bill it at 9 o'clock in the morning, and then she tries to get health insurance to come in to fill her pump at home, she can't because they already billed it.
Yeah, well, you won't let them bill it in the future.
But how can we not? We're paying for the insurance because they're saying we have no, that's my point. They're saying we have no standing. I can't stop it.
Well, you might have standing under our North Cyprus case.
That's my point, Your Honor.
So what we're talking about is beyond standing. Standing, do you have redressability? Can we give you anything?
Right. So, and I agree with Your Honor. The only issue that the district court did at this case was the standing. We didn't get past that. So when we argued, Judge Malazzo said, I just want to hear standing. And she kind of tossed us out on standing. So we were never able to get no discovery, no interrogatories, no request for production. She threw us out immediately saying, you don't have any standing. So my point, Your Honor, is we do believe we have standing. And once we have standing, we certainly have redressability because once you take something that belongs to someone else, you then have to replenish the value of it, right? So the fact that this client has the right and had the right every day to have home health come into her home and perform these services.
You didn't specifically say the words injunctive relief or declaratory relief that would be the thing that what you're talking about is some sort of declaration going forward or injunctive relief.
I think what we're asking for is either perform the services, which is what we did ask for. You're not performing the services. Or if you're going to take that money, right, and you haven't performed the services, you need to give it back. We know.
Specific performance in the future to come out to the house.
Or if you're going to do it and not come out to the house, then you need to give us the value of what that is, which we now know to be $120 per day. What's unfair, and again, the reason why I believe this is a problem for the patients is that all across the nation, this isn't a state thing, across the nation, the patients are paying premiums. These guys are billing $120 a day times, I don't know how many thousands of people not providing the service. So how is the patient not have standing when that money is coming from the patient? So
Who was providing the service before you found out about this?
They weren't.
Well, someone came to her house to fill the pump.
No one did. That's the point. She had to go.
Then how did she get
She had to
that?
go to the doctor. The doctor would fill the pump, and then she would go home, and there'd be no monitoring. It wasn't until she got all these EOBs that she realized, wait a minute, what is all these home therapy services? I'm not getting this. So no one was doing that, but she's entitled to it under her contract. She's just not receiving it. And they're billing for it at $120 a day for something that's not, I would agree, if they come to the house, that's great. 120, our client would love that. All the clients would love that. But to not do it and bill. And for standing, and I have a couple seconds here and I'll do rebuttal. For standing, this is what I like to say. Because AIS cannot act without Miss Randy Denning, they have to use her contract in order to do their billing scheme. Because they cannot act without Randy Denning must have standing in this case. And I'll reserve the rest of my time for rebuttal. Thank you, Your Honors, for your questions.
Thank you, sir. You've reserved. Mr. Werner?
Good morning, Your Honors. May it please the Court. Paul Werner on behalf of AIS Healthcare. For standing, an injury has to be personal and it has to be real. Dennings is neither. Regardless of what term she uses, and we've heard a few today, patrimony, for example, she's complaining about supposed harm to others, faulty payments made by her insurer.
But it depletes her ability to get that home health care because she'll be denied because they'll say she already got it.
Your Honor, I'm glad you asked that question because there is not a single allegation in Denning's petition that alleges that. There is this theory that she propagates around a reduction in her patrimony, and it's derived from a couple cases that I'd like to speak to you about, North Cyprus and Rideau, that this court issued a couple years ago. But that patrimony theory is built upon speculation on top of speculation, leading to a daisy chain that this court has held is not sufficient to create an injuring fact under Article 3.
Do you acknowledge that your company, billed for these services, but she didn't get the services? She had to go to the doctor to get them, et cetera. So, you acknowledge, not concede that there's billing over here for things that didn't happen?
No, Your Honor. And of course, we're on a motion to dismiss, so the allegations of the complaint need to be accepted as true. But I will point you to her complaint. What we've heard this morning from my friend across the aisle is a theory of the case that is completely different than the petition that she actually filed and the arguments that she made before the district court. She alleges in her complaint that AIS provided services that she did not authorize and billed for those services improperly.
Is that true?
I'm sorry.
Is that true?
Is what true? That we
You just said that you billed for services you didn't provide. You
No,
didn't
Your
go
Honor.
to the house. You didn't do any of that.
No, Your Honor, and this is, of course, outside the factual record here, but no, we billed for services that we are entitled to bill for under the codes that we use to bill for services. What AIS provides is...
It's like a non-answer.
I'm trying to answer. We billed for services that we did provide. We provided two things. We provided her pain medication, which we created custom for her, and we billed for ancillary services, administrative support, coordinated care, and around-the-clock supervision of the patient, all of which we
Go
provided.
to her house.
We did not, nor...
Around-the-clock supervision.
We provide a call-in service for her, that she and nurses on demand to her. The codes for which we bill do not require a nurse to be there. As counsel stated, the medication that she's provided lasts about 90 days. So we fill the pump drips medication to her, and then we provide service to her because she's essentially under our care on a 24-hour basis while her medication is running through her body.
So the service is that she can call this phone number if she senses that something's going wrong for 90 days.
That's true.
And that costs $120 a day.
That's what the codes permit AIS to bill for. But of course, that's really not the issue here. The issue is her standing to challenge amounts paid.
Right. Even where a patient did not get billed for out-of-pocket and did not have out-of-pocket expenses, the patient had standing in the North Cyprus case for fraudulent billing issues.
Well, Your Honor, North Cyprus, of course, you'll recall, invited providers who actually had not been paid. The patients had assigned their benefits to the providers, and the insurers refused to pay the providers the out-of-network costs they were entitled to. That's fundamentally different here. Those providers were out money they were entitled to. This patient, Denning, is not at all.
But it's the patient's injury in fact that gave the providers the injury. They talked about the patient's injury in fact in detail in that case.
Yes, Your Honor, that's true. But
that is true even if they didn't have any out-of-pocket expenses and that they didn't demonstrate that they didn't get care that they would have otherwise gotten.
That's true because the insurer refused to pay the amounts that the insurance provided, so those patients would have been on the hook to pay those amounts.
But they did not, they were not on the hook. They did not, it's fact, in that case, the case says specifically that the patients were not to be billed and were not billed. They were not going after the patients. And so they were not on the hook. And we still said that it's the patient had an injury in fact.
There's no question, you're right, but again, it's the injury in fact was the insurers refusing to pay for the services that were provided to the patient. That's not the case here. Denning's insurance covered the services and were paid for by the insurer, which gets to another question that you had asked opposing counsel, which is, what's the relief? Well, the relief that is sought in the complaint is different than the relief that has been represented to you today.
Well, maybe it should be remanded to amend. If the court is wrong, if the district court was wrong about standing, then the plaintiff should have an opportunity to amend to see if they can plead a redressability, shouldn't they?
Yes.
The court hasn't actually ruled on it yet?
If the district court was wrong
On standing.
which we don't think the district court was, because you need to have a personal and real injury, which Ms. Denning does not, because her insurer covered all of her claims and she has gone out of pocket nothing. It is not enough.
But it counts against her insurance.
There are no allegations that that's true, Your Honor. None. There are no allegations in the petition of that.
Her counsel said this morning that she had to go to the doctor to get the medicine, but you said the pharmacy provided the medicine. So what's true?
Your Honor, the pharmacy provides the medication to the physician. The physician actually puts it into the pump. AIS is a compounding pharmacy. It creates patient-specific custom medications that are then go to the physician, and the physician fills the pump.
So that was what was supposed to happen.
And I will tell you that that is what happened.
Yeah.
So you're saying that there's nothing that she contracted for, paid for, that did not occur?
Yes, Your Honor,
Is that what
that's
you're
true. Of
saying?
course, that's beyond the record, and we're on.
I know, but we can't decide a case without getting a fuller understanding of what transpired. I get you that we're limited to the complaint, but we put this thing down for oral argument, so we're trying to get a full sense of this. On the one hand, something seems not quite right if person doesn't get the services as billed, and on the other hand, you say no, not that. So we're just trying to figure out the reckoning. Does it need to go back or not? We ask counsel, obviously, you're looking for an injunction, you're looking for declaratory relief. No, you're looking for prospective relief. So, kind of what is it? You characterize and say, well, it's a claim in search of I forget how you phrased it, but you got to give up the goods here in a way to tell us what really happened in order for us to fully appreciate how to resolve the case.
Absolutely.
That's all we're trying to
Sure,
get
and absolutely, Your Honor, and I will answer you directly.
Yeah.
She received everything that she was billed for. The dispute is whether that use of the code is proper or not. But she was billed for what she received. She was not billed for something that she did not get.
So if she had an expectation that somebody was supposed to come to her house and do something, that was a misapprehension of what she had contracted for. Would that be?
Yes, Your Honor. And the contracts, which are at 48 and 49 in the record, of course, are not particularly detailed. One, at 48, is just an authorization for AAS to provide the services that are authorized by her physician. And then at 49, there's an assignment of benefits that allows AAS to bill her insurer and notes that she can be responsible for amounts that are not collected from the insurer. But
In order to answer that, don't we have to get an expert from each side these codes experts that you have, and they come in and they talk about, they do these in these fraud cases that the government brings a lot of times, where they say this code is allowed for this reason and this code is not, so we would have to have that factual dispute and probably some experts to tell us whether or not she did or didn't.
Absolutely, Your Honor. If the case were to proceed, there would be a quintessential battle of experts over the intricacies of medical billing, which is fairly complex. But before anyone can get there, there needs to be a plaintiff that has actually suffered a personal and real injury, and Ms. Denning has not.
Is this contract over? Is the contract over? Are you still providing?
I believe that we are continuing to provide service to Ms. Benning. One of the, again, this is outside the record, but just to share the context with you, once these patients are implanted with these pumps, the pumps need to be filled on a regular basis, and they cannot run dry because that would cause the patient serious harm. So generally speaking, when a patient is implanted with one of these pumps and receiving the medication, that continues on indefinitely.
Who decides that your company is the company to be used to distribute this product? Is it the doctor has a relationship with this compounding pharmacy? Who is making the decision to use because is this pain medicine available or some comparable pain medicine from other providers, I assume?
Well,
and it might come to her house. And so who is making the decision that this company should be the provider?
Sure, it would be the physician in consultation with the patient, but I will tell you there are very few compounding pharmacies with the stature and reputation and abilities that AS has. So there is not. This is not one of those things where you could order just online or something.
Are you saying you have monopoly power in the situation?
I am not. I am not saying that. I'm not saying that at all, Your Honor. If there are no further questions,
Well,
I'd like to thank the court for the time this morning. And
why isn't this, to state something that seems simple or obvious? I'm about to get a question out in a second. You're anxious to go back to your seat, but I'm just trying to figure out where the deal here is. To the point, what's your response to his diminution of patrimony argument? Your argument is that that's not pled in the complaint. Is that your initial argument? And what counsel opposite argued to, are you saying much of what he argued isn't laid out in the complaint? Am I reading you?
I'm saying that nothing that he's argued is laid out in his complaint, Your Honor, and that theory is built upon many speculations that.
So if we go just based on what's in the complaint, ergo no redressability, that's what you say?
Yes, absolutely. Well, in addition to the fact that she does not have an injury in fact, her claim really also founders on the shoals of redressability, because without any injury, there's nothing to redress. And this is one of the major problems with her complaint, which is she's really seeking a windfall. And this is something the district court recognized. She's not out of pocket a dime, yet she seeks to represent an entire class to recover monies essentially that were paid by the insurance companies, which really raises this question of, well, what then does it mean for the insurance companies that actually paid those amounts?
Well, it could affect her premiums going forward, that they're paying out big giant claims that are not founded well, because the insurance company will be not as successful. And that is a theory.
It is, but it's not alleged in her complaint, and there's no evidence of that, and her insurance paid the claim.
Redressability?
I'm sorry, Your Honor?
Did you argue specifically redressability?
We absolutely did.
The district court chose not to rule on it?
No, the district court did rule on
I
it.
thought the district court ruled on standing.
The district court ruled on injury in fact and redressability all
within that context.
Yes, Your Honor.
Okay, I'm sorry. Then I have a question. You concede, though, that the district court was wrong to dismiss the case with prejudice, right?
A ruling based on a lack of subject matter jurisdiction should be without prejudice.
So the answer is yes to my question?
Yes.
Okay, thanks.
Yes, it is, and we would ask that the decision be affirmed as modified. That is something that this court has done, an approach that it has taken in other cases, and I just cite the court to a recent one, Sure Shot Golf Ventures versus Top Golf International at 754 Fed Appendix 235. And there are a number where district courts have ruled on subject matter jurisdiction and dismissed with prejudice, where this court has affirmed as modified.
All right, sir.
Thank you, Your Honor.
Thank you. All right, back to you, Mr. Richardson. Off the bat, just clarify for us, because I don't have it up here in my papers. your argument within the context of what you actually pled, because that's getting a little bit confusing in terms of, you know, you've given cogent responses earlier, but we got to stay within. So is it the case that maybe other things to be pled, you know, if you get to go back and amend, or within what you did plead, what do you say to counsel's arguments when he was just up here, you know, about the patrimony and the rest of it?
Sure. And I agree, Your Honor. To the extent that they would want us to plead more specifics, could certainly do that in an amendment. But what I tried to do when I filed this, again, because I can't get into discovery yet, I tried to plead as broadly as possible in several paragraphs. But if you look at starting at 24C, where it does say, and I'll read a couple of them, as a consequence of AIS's billing plaintiff and or plaintiff's health insurer for services not rendered, plaintiff's patrimony has been depleted where plaintiff either personally has paid for services and where plaintiff's insurer has paid for those services. The amount of insurance coverage available to plaintiff for a particular term has or has been improperly depleted through AIS's actions. I further state in paragraph D, plaintiff's right to demand return of the thing or the value thereof is prevention of unjust enrichment, which would otherwise accrue in favor of a transgressor. We also allege in paragraph E, equity demands its return. Therefore, plaintiff seeks restitution of sums wrongfully billed and received by AIS. And then I also cite Code Article 2299. So I was trying to plead broadly that her patrimony has been reduced because they took a thing of value. This right to have home infusion therapy is a thing of value. They took it from her. They billed it. And therefore, she can't have it from anyone else because they're billing it and not providing it. But I do think there's a little bit of a misconception about what's happening here. And I think, Judge, I'd like to address a couple things. They're not providing the services. They say they are. Remember, they're getting paid for the medicine. So my client gets with their insurance company, and she gets this medicine for however many days it is, 30 days supply or whatever. That goes to the doctor. She goes to the doctor and the doctor puts the medicine in the pump. They're paid for that. They already got that money. But then what they're doing, on top of that, however much they're getting for the medicine, they're charging an additional $120 a day for the medicine to go through the pump. And this is in the record. It's record 5-1. This is their motion, their memorandum. It says on page 4, AIS charges a per diem amount for each day a given patient is provided access to a prescribed therapy. Those charges apply each day the patient's intrathecal pump infuses the medication, beginning the day the therapy is initiated and ending when the treatment is discontinued. In our view, that is wholly inappropriate. My client already bought the drug. It's her drug. The fact that it drips a little bit into the body every day doesn't give them a right to charge her another $120 a day, $3,600 a month, $48,000 a year.
Well, they're not charging her. They're charging the insurance company.
True.
Is there any evidence that her premiums have gone up or that she's being cut off by the insurance company because they've maxed out?
No, her EOBs have been determined, right? And so she can see those. But the problem we have, Judge, is I can't get that therapy. I cannot get another. There are other companies that do it. But I can't get the other companies to come to her house, infuse it, because they're already billing for it. I can't bill it twice.
But he keeps saying, maybe I'm the only one missing it. You seem to be arguing as if she's entitled to have somebody in her home to provide the service. I declare I heard him say, that's not what you contracted for. She didn't contract it. He says she contracted for what I would call outpatient services, that they pay for somebody else to do it, and that's what she got, so therefore no breach. Maybe I'm the only one missing it.
That's where we have a formal disagreement.
Yeah, see, maybe I'm missing it. He's saying she got, the billing is what she contracted for. Her to go somewhere, they provide it, and she gets it. You seem to be saying, well, She thought they were going to show up at her house to do it. They didn't, yet they billed for that and they got paid. Now, somewhere between all of this,
This is what my point is. In discovery, it's going to show she's not getting any of that. All she gets, she goes to the doctor.
but without discovery, how do you read the contract? The very contract that's at dispute. Just
Okay.
stay there for a minute. I know the light's red. That's the only shade it's going to turn, and I promise you it'll stay like that till we get through, right?
Right.
Okay, but I'm saying, what do you, when I say you on behalf of your client, say that the contract is to provide for? Does it not, just reading the contract, does it not, or does it say services, but these services rendered elsewhere?
No, I believe that the way the contract reads is that once AIS prescribes a particular therapy, whether it's the medication, if they bill for the medication, then they give her the medication. And they're doing that.
No, I'm not asking what you believe. I'm asking when you take the contract and read it.
Right.
Plain language, read it.
Right.
Tell me, so we'll find out, where in the contract, the paragraph and lines that say entitlement to in-home services or some words to that effect.
I authorize consent to AIS providing services to me pursuant to the orders of the physician, name above, whose supervision I'm receiving medical care.
All right, so tell me in what you're reading where it says such services are to occur in my home or such place as I designate.
That's the point. They're billing, they're going,
Yeah, no,
they're
that's
breaching
the
the
point.
contract.
That's why I asked you the question. I'm saying, tell me
Right.
in the language, though, are you reading? I heard you about the services. I'm not trying to be obstructive. I'm just trying to understand it. And I know you're between getting tossed out early, so there's a lot you haven't found out. I got that. I'm just trying to say, at its essentials, this is a suit over the contract. We get those all the time. People sue for us to tell them what they agreed to, right? So I just want to know where in the contract it says in language to the effect that she's entitled to personal services in the home or something to the effect. That's all I'm trying to find out.
We specifically, does the contract say that? It does not. We have alleged fraud because they're using that contract to then go to the insurance company and say, we're now going to bill these codes because they are, according to them, authorized under the contract, and we get the money for it. So that's my point, Your Honor, is it,
Gotcha,
it doesn't say that.
But isn't it a basic jump-off point for us if they're correct that she got what she was entitled to, i.e. the services to be provided somewhere but not in home, then doesn't that bring us back, though, to where we've been all the afternoon, to the whole redressability point? That's what we're trying to get, not to be a windfall to them, but to get to the point of if the contract doesn't specify in-home services. There's no disputing that they're billing for a whole lot of stuff, but how do we get to find the claim is redressable if we can't say that within the corners of the contract she's paying for something that they didn't offer?
I just believe they took the contract and fraudulently turned it into something they weren't entitled to receive. They breached it. They didn't agree to what the contract said. The contract says certain things. They expanded that beyond what the contract was allowed, used that to their own benefit to get $120 a day to my client's detriment. They abused the contract, not my client. My client signed the contract as it was. They took it, morphed it, used it to their benefit, and because of that, our client does have standing, and she is injured. Her patrimony has been depleted. She can't cover that code. And
If you get there,
I get there.
I definitely hear your jury argument. Okay?
Thank you, Your Honor.
I got it. If you get there, you got the jury argument, but we got to get out of dry docks first. All right, not to belabor the point, we're just trying to get an understanding. We appreciate counsel for helping us out with the briefing and argument. That concludes the cases that we had for oral argument today. The panel will be in recess until 9 a.m. tomorrow morning.